I'll find the PowerPoint to be sharing. I believe you're seeing my PowerPoint.
Yes.
Perfect. Yes. And and David K was going to join me, but he had something come up, I believe, at the last minute and can't be here today. So we were asked to talk about the economic and legal issues facing sort of some large scale solar development and agrivoltaics. We don't have a lot on agrivoltaics, but I'll talk about that as we go along where it fits in some of this. Um, this was all the stuff we have done working with David, and then we worked for those that know Shannon Farrell at Oklahoma State. We worked together and we have a publication coming out that will hit solar leasing issues in all three states. That has ability to be used across the country. This was all funded by USDA NIFA. The project actually ended a year ago, but I still put the stuff in there. And I don't know how familiar you are with solar development across the US. We've seen it dramatically rise in various forms across or over the past few years, with more and more states pushing for some renewable energy, where wind has not been available for some to take advantage of. This has become one of the alternatives that folks have looked at. If we're looking at wind compared to solar, this is going to have a much larger footprint across. Typically, where we see it go in is farmland, just because it's typically undeveloped, it's open, and it's easy to go out and put solar panels up and get a facility going quickly. And if we want to, towards the end, we can talk about some of the various um, forms some of these projects take. Um, with all of this, as we see landowners get these agreements to lease, they're typically going to be three agreements tied into one agreement. And I'll talk about what those three agreements are here in just a minute. But with that, the main reason we're seeing it go that way is instead of negotiating with the landowner at three different stages along the way, we're really just tying it in if we're the developer at one stage. Because if we look at it, when does the developer have the most power throughout this entire leasing arrangement? It's always going to be at the start when the project is not fully formed, it's not permitted yet, it hasn't done all its interconnection requirements to get into the grid. So it's going to have the most power. Then the further along they go, the landowner starts gaining more and more power, because they're going to want this project built if they're the developer, and they're going to have to agree to this. So industry standard has just become to negotiate this all at one time with various forms this can take. And we decided within everything we did, the language differs from lease to lease, but really we're looking at an easement period, an option period, and then a leasing period within all that. And if you have questions, feel free to put them in the chat and I can try to answer them as I go along. So if we look at this easement period, this is going to be just when that developer is going out. They're going to have the right to come on the farmland and start looking at doing survey work. They may put equipment out to test, impact of the sun and various points where it's going to be the best spot to put the project. This typically, from what we saw going through leases, was anywhere from 1 to 2 years. There would probably be extensions included in that, depending on just how many other projects the developer had in the queue and how long it took to start doing some of this initial groundwork within that. If we're looking at it from the landowner standpoint, they're going to be able to continue to do whatever they want to do on that property during this period. There's no limitations on them. The developer or the landowner, if they're doing their due diligence, will have included in some ability to go back in and get crop damage or just damage to the property if something goes wrong during this phase while all this survey work is going on. Typically, it should be minimal impact towards them. The next period after that, if they decide to go forward with the project, then they'll exercise it to move into the option period. With that option period, they're really going to start doing all the necessary work. They're going to be going out, doing financing, getting the financing they need. They'll be going through the permitting process, depending on the state they're dealing with. I'm here in Maryland. If the project's over 2 megawatts, they're going to be dealing specifically with the state throughout the whole process, the Public Service Commission. If it's under 2 megawatts, then they're dealing with county zoning and planning throughout the process. And depending on which county you're in the state, it can depend on how easy that's going to be or how hard that's going to be. And a lot of these we're going to be dealing specifically with the state to go through this process. In some states, we may be dealing with both, depending on just how zoning and planning works in those county or in those states. The landowner can continue to utilize the land during this period. There's really no limitations on them. This is really where the developer is going out and getting all the approvals necessary to start building this project. Once they get all that secured, then we move into the lease period. If they do not get it approved, we will never move into this period. And I see something in the chat. Oh, so the question is, water landowner payments, are they reasonable for the easement option period? They're usually pretty reasonable. Within that, they usually are. I've seen them everywhere from $1,000 to more during those periods per acre, and they may tie up the entire parcel of property during that period. I've seen some that are just a flat fee during that period, not tied to the acre. They may be a couple of $1,000s just to tie the period, the farm up during that period of time. Once they get all the necessary permits, then they will be able to exercise the agreement to move into the lease period. This is where they're going to start putting in the panels. And excuse the fact that I put turbines in this. I was explaining earlier, this was an older deck that I thought I got updated properly to take out the wind turbines when I did it for another group that wanted panels and solar and wind discussed at the same time. Within that, they're going to start doing all the construction. They may, in the agreement, have built-in places where they'll pay to put equipment during it, material, anything they need to put in. Typically within this, with construction, we'll see minimal concrete slabs being built. The most that will be built will be for the power inverter. The power will have to be converted to get into the grid for this. So it'll be, depending on the size, there may be 1 or 2 power inverters built on the property. There may be substations built on the property depending on the size during that. So there'll be a construction period. Then once that's built, everything's put in place, the operations will go into effect. The landowner is typically paid for the size of the project, depending on the number of acres taken up by the project. And that can vary dramatically depending on the state you're in. The one good thing most of these agreements are doing now is they really are putting into place in the back or within the first couple of pages, sheets to kind of tell the landowner, okay, during the easement period, you're going to expect this much. During the operations period, you're going to be expecting, or during the option period, to expect this much. And here's what to expect over the life if we get to the lease period. And I'll talk more about that when I get to payment here in a second. Then at the very end of all this, there will be a language in it to go through decommissioning and removing this whenever it goes into play or removes. Typically, when we've been looking at these will run anywhere from 20 to 30 years once we get into the lease period. There'll be automatic extensions in there, and I'll talk a little bit more about that here in a second. The landowner will be limited during this period of time, so they don't interfere with the project. They typically will have no access to the site during this period. There'll be fencing put up with locks on gates that they typically will not have access to, mainly because who's ever at this point, it may still be the developer. They may have sold it to a company that's going to run that for them. We see that a lot in Maryland, where we have developers who will develop the project, but they already have in mind someone who's going to take over the project once it's built. Typically, landowner is going to be kept out. There may also be restrictions in what they can build next to the project. They will not be able to build structures over a certain height, so they don't interfere with the sunlight that's going to come on the property. And they'll have full access to the property. So if the landowner has a gate with a lock on it, they will have to have access to the gate to get onto their project. Oh, okay. So as we look at these agreements on the developer end, the biggest thing is that's come up is they got to make sure that this property is properly described correctly, that they actually know it, that they're actually signing up to get the property that they want. And the landowner really needs to go in and verify a lot of this is correct for the property in question. The other thing that comes up a lot with this is in some states, developers, and actually the majority of states, developers really never have to file anything in the land records. In Maryland, the only time it would become really anything that would have to be filed in the land records is once we hit that operation stage or that lease period where the lease is actually kicked in because it's a long-term lease and they want to come on for that. Landowners really can't lease this property to multiple developers at one time. That's come up in a number of presentations where what is the ability to stop the landowner from doing that? Well, they've given up the right to do that within the agreement, and they can really have the first developer come back and start suing them if they start trying to game the system and take into consideration more leasing opportunities. It's not like oil and gas, for those familiar with it, where leases would be filed in the land records. Really, in most states, that's not going to happen. In some states, we would start seeing that more and more as we go along. Are there any questions as I try to get myself a drink of water? So with this, if you're dealing with this, you really got to think about some terms, and this is something we pulled into the publication we worked on for a couple of years to get folks out there. There's terms out there, and I can share this presentation with you guys at the end if anyone wants a copy of it. I'm happy to share it. The developer really is going to have access. We have to think about what that access is going to be. There's going to be access to evaluate the site, construct, operate, maintain the equipment. I should point out the other question that comes up with this access issue that I hear a lot is what happens if the panels become obsolete? That probably shouldn't happen over the course of the lifetime of the lease, but if they actually want to release the property later, they may come out and put newer, better panel technology up at that point. Construction during this, it's really just going to be focused in on what does it take to construct, where the laydown area is going to be for that equipment, for the materials coming in. Like I said, construction is going to be pretty minimal. It will typically be poles pushed into the ground or minimal concrete. Oh, I heard somebody talking. Oh, transmission. We got to think about what that's going to be. Is it going to be up above ground, below ground? What lines are gonna have to be put in. Typically, depending on where it may be, there maybe have to a line upgrade made to get it to the line that could be able to carry it. Typically, the company will pay for that upgrade throughout that. We're not going to be able to obstruct during any of this. We can't interfere with the light patterns as the developer has them at that point. They need to acknowledge there's going to be some glare. There may be noise because there is a power inverter on the property and some other equipment that will make noise. But for the most part, we haven't seen any lawsuits associated to that. We've seen much more in the wind industry than we have with solar. Glare is often minimal because if we think about this properly, the panels actually should be absorbing sunlight and not reflecting sunlight back. So glare should be minimal. And in a lot of cases, if there's concern about glare, developers will do screening around the site, either plant tree rows around the fence with shrubbery or something that doesn't interfere with the sunlight down the road, but will help prevent the glare and help prevent neighbors from seeing it and getting offended that they now have a solar facility next to them. So what are the timelines with all of this that we talked about with those periods? Typically, like I said, with easement, 2 to 3 years. Typically with the option period, it's going to be around 2 years. It may have some extensions in there that they can do depending on how backed up things are. If they're trying to do interconnection, that may be a backed up process. For those that live within the PJM interconnection area, which do not ask me to remember all 26 states that are in that. It's typically the Northeast and a little bit of the Midwest and part of the Southeast. That's had a very bad backlog in getting solar approved for interconnection. At times, state permitting processes can take a while depending on what that process looks like. So there may be some extensions that have to be filed here with the landowner just to keep that option period going. Once we hit the lease period, that's going to be the longest period throughout the whole thing, 25 years or longer. Early on, we were seeing leases a lot longer than 25 years, but it seems like right now industry has gotten to about 25 to 30 years with maybe 2 to 3 automatic extensions that the developer can utilize that are about 5 years each. So we could see this agreement going on 15 years past that. So maybe up to about 45 if it's a 30-year lease. Finally, discount the second bullet. I missed that slide too. When we get to decommissioning, this will be included in that lease period. This is a period that's going to take a little bit of time for them to do, and we'll talk about that towards the end of the presentation. That really is going to be where those panels are removed, any infrastructure is removed, the fencing is removed, all that, and the property is supposed to be returned to the ability to be used again for whatever purpose it was used before the solar panels went up. I see I have something in the chat. Oh, and David is here. So if David would like to chime in at any point, I am more than happy to have David chime in, and if he wants to introduce himself.
Thanks, Paul. Apologize to everybody for being late. I'm in the middle of a conference in Kansas and had trouble getting access, but I'm good now. I'm actually at a community development conference at the moment. I am an emeritus faculty member at Cornell University and have worked on energy, climate, community development kind of work for a long time and collaborated with Paul for quite a while on particularly on the large scale solar. I've also worked specifically on agrivoltaics kinds of topics, which is a subcategory of this kind of work. And I will look forward to complementing anything I can if and interrupting Paul, so because I've done that in the past and probably will again.
I was gonna say, I think we set this up so I would lead and you could interrupt, so you did not have to put anything together.
Yes, thank you so much.
So yeah, so feel free to just chime in at any point and tell me to shut up. Okay, so payments. And this is one of the areas where we worked on a lot within this, because when we started looking at our focus groups and with this project, we did focus groups of landowners who had signed leases and landowners who were considering signing a lease. We also interviewed attorneys to get ideas as to like what land they would want landowners to be thinking about in this process. So one of the biggest takeaways we took, as most of you on this call may um, already know, they really wanted to know in most of this, are they being paid fairly? And not only fairly, but are they getting at least a similar amount as to someone else who signed a lease in the same area as they did? I do not have the table in here, if I remember correctly, of just what all that range of prices was, and that will disappoint Elizabeth, who's on the call as well, who worked a lot on that table with that. But the reason I didn't include it is we did this work in 2021, 22, and a lot of those lease rates are 4 years old and they're higher now than what we saw back then. They were in the just, $1,000 to $2,000 range, and they've gone up dramatically over that time as more and more folks wanted to get that. One of the things we learned in this, and we talked to a few developers as well, that we really could never get a focus group together of developers. One of the biggest things that came into this was those higher rates are often tied to the financing of the project. So if the financing is tight, the higher rates may be harder to get within that. Where we've been seeing the higher rates, at least in Maryland, and I don't know about New York with where David's at, is a lot of our higher rates have come to something that is very similar to large scale solar, but is often smaller. It's community solar, where typically it depends on how your state is set up for community solar, but there'll be subscriptions sold into that through your local power company. And within that, those people have the ability to then, their power is coming, quote unquote, from solar within that. In Maryland, there's some requirements that part of that power is set aside that low income can actually take advantage of it too within that. So it all depends on how that's set up. Where we've seen those higher lease rates has been within community solar here recently, just because of how those projects are financed, is what I'm starting to think.
I'm,
Go
you
ahead,
want me
David.
to, I just might throw in that the, the legal, structure that enables community solar to happen does vary a lot by state. Some states don't even allow it at all, but the scale of the project, regardless from very small facilities to very large facilities, does matter. And that, and by very small, we're talking about, neighborhood scale, very small scale, just serving a very small number of off-takers up to, many, many massive ones. You may have talked about this already, many megawatt facilities. And there is some, in the work I've done, there is some weak correlation with size that I've seen in New York and some other places that does privilege smaller facilities on a per acre. You might just think of it as they don't have to pay as much. And acreage is pretty important for the large facilities. They do pay in the range that you mentioned. They have been paying, and it has gone up. But there's a lot of uncertainty in some places, in particular, but the country as a whole and the solar industry right now, because of policy changes around it. So I wouldn't want to predict, independent of knowing what the future policy is going to be, what the rates will look like in the future.
No, that's a good point. And then with this, as I've kind of mentioned before, most of this is going to be per acre per year. When we're in that option and that that easement and option period, that may just be tied to a flat fee, depending on how the lease is written. I've seen it either way. It can be a flat fee. You know, we're gonna pay you a couple $1,000s an acre and I've seen upwards of $10,000 to hold a property for a period of time. And if it's a flat fee, it'll probably be paid annually over the course of that period, not just once. At least in all the leases I've seen. When we get to that lease period, it's going to be per acre per year, and it's going to be per acre per year for the amount of land tied up in the project. And that will include, if they have to run a road to the project, they will include the road within that, or they're at least supposed to include it. We do not see royalty based for those that are used to oil and gas, or even some cases in wind. There are some out in the west that are tied to royalty payments. Most of this will be per acre per year. There will typically be an escalation period within, or an escalation number within all this. It can be tied to an inflationary index if that's what the landowner can get out of the developer. Typically what I've seen is it's just tied to, 2 to 3% a year. We're just going to inflate the prices 2%, 3% each year once we get into that period. And I've seen in a lot of the cases with a lot of the leases that have been coming out over the past couple of years, that's where I've seen the payment schedule in the back, where it will show all the payments for the option period, or the easement period, the option period, and then the lease, and then give them a total number at the end to try to entice them to sign. It will be in the millions of dollars, more than likely, and it will assume that they're going to lease the whole site. When in reality, they're not going to lease the whole site unless they're going to build the whole thing as suitable for solar, and it's just going to go out of whatever use it currently is in. Typically, it's going to be a smaller scale size, depending on the megawattage needed for that. And as we often point out, if there are some landowners who do want to consider royalties in this, I have been in presentations with lawyers in Texas talking on this subject, and they have said they will not consider any lease for solar that does not include a royalty payment. If they want to go that route, they really got to keep in mind that they're going to have to get access to records and the ability to check the logs for production on that site. And that's all going to be controlled by the company. So they're going to have to negotiate in some ability to look at those records. We have not seen a whole scale push towards that, really. If it is, it's limited to states that have an oil and gas history where that's what landowners want. Before this project, we had, oh, go ahead, David.
Yeah, I might just add that, in theory at least, and I think mostly in practice, that the revenue streams that's going to come from a solar project are going to be much more dependable and and much more likely to be able to be anticipated than the revenues from an oil and gas well. So in some ways, the uncertainty that's associated with how much you're going to get out of oil and gas, which is captured more in a royalty type payment structure, is less important to deal with, and when you have a dependable revenue stream. So I'm just saying I think that's one of the reasons as well that that lease payments make more sense and are more common in the solar industry.
That's a good point. And I got ahead of myself and already talked about this slide, but yes, they're all going to carry different rental rates. It will also depend on what part of the country you're in as to what the rental rates are. It may often depend on what part of the state you're in. I've seen some of our more northern counties get higher rental rates per acre than some of our eastern shore counties that are much more predominantly flat. And if you haven't been to Maryland, the northern part is not as flat as the eastern shore is. So a lot of those higher rental payments have come up north than they have on the eastern shore. Uh, as I already said, it's typically tied to the lease. The lease period is going to be tied to the size of the project and the infrastructure associated with it. If they have to run power lines in, I believe that also counts as infrastructure, and they will tie it in. I've seen some where they tie it into also if there's just they have to put substations on, they just pay X per year for substations. So what are some of the rights of the landowner and developer? And then I'll give David some time to expound on agrivoltaics with this too, and I can talk about a little bit within Maryland. Whatever happens, the landowner is going to want to think about how do we keep existing uses that this property may be useful for. If it's agricultural, we're going to make sure we still have the right to use it for agricultural purposes. Some parts of the country, it may be hunting. Recreational uses, want to make sure that's preserved within it. Solar is probably very likely going to limit the ability of the landowner to hunt on the property. And they're going to have to think about how to negotiate that in, because if we think about it, if something goes stray within that process, it's a panel. That's a large expense to the person managing that property now. So we really got to think about if they're going to do it, what are the ways that that can easily work together. And companies are willing to work on that, but some may not be as much as others. So that ability to hunt may just go away on that property. One of the biggest things to think about within all this is it's one tax bill, as most of us know, that go out on property. Most of the leases will include language that says if the property taxes are going to go up on this site because it's become developed, that the developer ensures that they're going to pay whatever those increases are. Or if the landowner just wants to cover it, which I've seen in some cases with some of this, they just want to ensure that the lease rate is high enough to cover the taxes, plus give them a steady stream of income in this. But we want to make sure as we're looking at these that, you know, there, whatever happens with property tax increases happens in Maryland specifically, and it's only related to the smaller community scale solar projects. We have put in place a little bit on agrivoltaics. If you can document, the developer can document the ag practices that will take place on the site with the panels, you are allowed to continue to get your ag use property tax assessment on that property, and the property taxes will not go up dramatically throughout that process. And we are still waiting to figure out how that process will operate, because it just kind of went, it goes into effect in, I think today's the 18th, so it goes into effect in like 12 or 13 days. So we are waiting to see what that is. And I've had a number of developers reach out to me to be like, so what is this going to entail? And we still don't know what they're going to count as ag. We know certain things will not count. Pollinator plots will not count. And I think that's the biggest one that's not going to count. It's pollinator plots. It actually has to be agriculture taking place on the property. With all of this, the landowner really has to understand, like, what are the setback requirements and how is that going to impact how I use the property? All these leases are going to include some kind of setback that says within X number of feet of this project, you can't, you can do certain things that will not impact the sunlight. And after we get out a certain number of feet, you have, you know, the ability to build a building, do stuff. If we know, for example, we want to build, you know, we have a family member that wants to build a home, or we know we want to put a home on this property, we really got to figure out where that's going to go to help carve out some stuff within this. The other thing that comes up a lot in this is, and it often confuses landowners when I tell them this, if there is a mortgage on the property or other security interests, they need to go talk to their bank, because the lender is probably going to have to file some form of subrogation with any of those interests to make sure that the company will require it. They're not going to lease the site if they do not have some priority that they can keep the site on. if for some reason the landowner goes in default. The landowner may look at it as a steady stream of income to help them pay off the mortgage or any existing debt. The lender is going to look at, and the developer are going to look at it as potentially interfering with things they want to have rights to. I don't know if David has anything else to add in.
I think not, no, I'll wait until Q&A. I have some
Okay.
other things, but I'd rather wait.
Okay, I'll let you do that. To like we talked about, there's going to be some maintenance that goes on this property. They're probably going to come out and mow it periodically, may or may not, depending on that. They're going to have to prevent noxious weeds from coming on the site. Although I've heard from some folks that drive by them that they have become noxious weed factories within the state. They have to keep that down, and it will become their problem if they don't. They have to make sure that whatever permits they have on this site, they're maintaining them, they're keeping them in place. And this has become one of the bigger concerns, at least in Maryland. I don't know about New York and other states, because right now, one of the biggest things we're seeing going on in this is to help keep the sites clean, is just allowing sheep grazing to go on underneath the panels. We have a number of, at least in Maryland, and I'm assuming in New York as well, there are a number of sheep grazers who specifically rotationally graze sheep under these panels. And in some cases, if you go out to them and look at them, they will have no water set up. And yes, there is electricity flowing, but it is not in a form that they can fully utilize to run the electric fencing they will need to do this with. I was talking to one of our county ag agents yesterday who just started, and she and her husband run sheep, and they inherited contracts when they bought the sheep business from another farmer to go out and graze under solar panels in northern Maryland. And their biggest issue is they do not have electric and water, and they're having to haul water in every day. And they're having to bring marine batteries to run electric fencers at a rate that would be needed to control the site.
Paul, maybe I could just jump in there and mention that sheep grazing in particular has probably become the most well-established form of agricultural operation that is in most cases, in many cases, compatible with solar. It's often economically viable because it's a substitute, as you kind of presented it, it's a substitute for other forms of management, or it's a complement for other forms of property management that the developer would have to pay for in other ways otherwise. So that's good. There's still some questions about, even though it's sort of feasible and practical in a lot of ways, about how scalable it is, how fast can sheep grazing make sense on, in a sense, on what percentage of the solar facilities that are being or have been installed. So it's not clear how scalable it is, and that will vary by state as well. So, and the last thing I just wanted to say, that one sign that this is pretty well established is there's American Solar Grazing Association, which got organized several years ago when this was first getting going. And anybody particularly interested in the grazing aspects, especially with sheep, but not only with sheep, they have a great website and a lot of resources on it. It's ASGA, American Solar Grazing Association.
Yeah. Yeah, and sheep's where we've seen the biggest area. Cattle can potentially graze out there, but it has to be probably set up. I've seen some leases that would allow cattle to go out, but not that many. I think developers are still scared that cattle can impact the site enough that they don't want them out there I've seen research that shows that may not actually always be the case. With that, I've already mentioned this. I've had it from the landowner and developer side and putting this together, but with the developer, they really do need to think about, that single tax bill, making sure it gets to them. And then, how are we gonna document what those increases are over time from the site? To just what the property would have gone up just over time as property taxes change on properties just in any given period of time. And then they're gonna want to work with the landowner just to make sure that whatever things, existing uses that were still allowable under the lease stay within the terms of the lease and do not interfere with their development that they put on the property. The biggest area that also comes up with this is in all these agreements, there's gonna be something talking about how we have to indemnify each party. They're gonna agree to this, for anything that happens either on the site controlled by the developer, the rest of the land. They will typically agree to indemnify landowners for anything that happens with their project. Because if we're looking at it, who are we gonna sue? As a lawyer, who are we gonna sue in all this? We're gonna sue everybody whose name is associated with this, from the landowner to the developer. Within that, and same for the landowner's business, whatever's going on. If it's still a farming operation on it, we're gonna want to make similar indemnifications to the company because they're probably gonna get pulled into any lawsuit. Both parties will probably easily get out, but they're still gonna be pulled in and have some costs. And I see a question in the chat. With due diligence, on the operator in the pre-agreement, I would say the biggest is just understanding what's being leased and understanding the restrictions that are being put on the property from the landowner standpoint. If we're the operator, just understanding what those existing uses are that are going to be taking place on the property, so we can kind of manage that better in the long run if there actually is a project that gets developed on here. And I will probably come up with more as I keep going, but those are the first two biggest ones that came to mind. And the other one that comes up that a lot of landowners are shocked by is there may be increases in insurance levels that come up with this. The contract may clearly say that they have to carry liability insurance on the property at a certain level. And it may not be at the level they're currently carrying it at. And this will just be their general liability insurance. They need to think about what that's going to entail. They may want to look at how to negotiate that rate down. That may be something they can negotiate down. As we looked at these agreements, there's a lot of terms that are used in there that are negotiable, and there are a lot of terms that are not negotiable that financiers require. This may be one area, depending on what the financiers require, that they can negotiate that to a lower rate. For due diligence, that's one thing I would look at, is just what are the insurance requirements within all this, to think about, is this something that either the landowner or the developer can support, depending on which party it is. Okay, now we're gonna get to almost to the end of the agreement. All of this is gonna run for various stages. Like I talked about, typically we're looking at about 25 years to maybe 30 years. There's gonna be renewals, as I mentioned earlier. Typically, there's just a notification that has to be sent to the landowner by a certain day that they're gonna extend it. Typically, it's a letter, but in some it can be an email, depending on how it's written. Within that, if at the end of this, we get to the end either of the lease and there are no renewals, or we get to the end of all the renewal periods, all of this agreement's going to terminate. They will probably not terminate just on whims. As I point out to everybody, the question that comes up a lot also is, what happens if this person that's operating it files bankruptcy? They're probably not going to terminate the project because there's millions of dollars associated with that. The court's not going to terminate it. The court will probably sell the contract or let the developer sell the contract to somebody else, and they'll take over the site. Termination could also happen just because the developer or the landowner is not living up to their terms of the agreement. It may come to the end, they may not want to release it, so they may come in and decide to start decommissioning the site. I am going to talk about the Maryland example of this, and I'm also going to talk about what happens if you don't have the Maryland example, but I'm going to use the Maryland example as a way this is handled and way we're seeing it handled with other leases as well that may not follow under this process. So once the lease ends, whether typically we're going to see it get to the end, and that's when it's going to end. We haven't seen any of the things I've actually mentioned because these are so new. We haven't seen any of this develop yet. In it, there'll be a decommissioning language. In that decommissioning language, it is typically good for someone to include a bond within that, or a letter of credit, or some type of guarantee that they have the funds available to do this. Typically, I see a lot of these written where they'll just say they're going to remediate the site, and they will not put forth any language as to how they're going to put the monetary value on putting money aside to make sure they can actually live up to that obligation down the road. And most attorneys will negotiate for that when they're working with these landowners within that. That is another due diligence area to think about, is just what does this remediation period look like? And how are we documenting how the land needs to be remediated to fit into that standard? Oh, and I need to hurry up because I was going to give us 10 minutes for questions. Maryland, you go through this certificate of public convenience and necessity, which is what any power plant would go through if you're over 2 megawatts. Typically, the company has to put a bond up over that period of time. It is a bond that is reviewed every 5 years. Landowners may want to do this. I'm just going to go through this quickly. This is one thing we asked our legal researcher, Holiday Hull, to pull this together and think about what would this cost to clean up a site. So this was a table she found, and I cannot remember where she found it from, or I would have given it accreditation in this. We can see that at 20 years with a 2% and 2.5% inflation rate, we're looking at about $98,000 to remediate the site. I just took that out and extended it to 30 or 40 years to show you what that might look like. And this was a 2 megawatt ground mounted facility in Massachusetts. In Maryland, with some of the sites, we have 150 megawatt site on the lower eastern shore of Maryland. Estimated decommissioning was $17.8 million. This was early in the process. Salvage value, $16 million. They're allowed to take salvage value of the equipment into consideration as they do this. And they were only required to put up a bond. They had to put up a bond. The state law is written to where the county where it's located gets to decide what they do. I do not think any county ever takes a letter of credit. They all want a bond. They were able to put up a bond of $1.2 million, close to $1.3 million for that site. We had another Hartford County site, and this is always my favorite one to show to landowners. The removal to clean up the site was estimated at $2.2 million. Cleanup or estimated salvage value was close to $3 million. So they only had to put up a bond of a little over $250,000. And they all get mad at this, but I often point out this is just at one snapshot. This was the first 5 years. In 5 years, this will change. In 5 years, this will change. In 5 years, this will change. Salvage value of that equipment is going to go down over time, and those estimated decommissioning costs may go up. So we're going to see bonds increase over time. One of the things we've seen, even with smaller sites within the state, is most landowners and most of the counties are requiring that to permit it, that the agreement has to state that there's some kind of bond in place that's going to have that 5-year review of what it is. And most of the developers I've talked to, at least in the state, are willing to accept some sort of 5-year review to take that into consideration. That was one of the reasons why we were looking at decommissioning cost and estimating them out over inflation, was to kind of get like, well, what should a landowner be looking at? And this seems to be a better way to do this. Some states will require it to be put up in increments over time, with no look back, but a lot, it's probably good practice just to include a look back. We've done some stuff looking at data centers and those that are being leased the land, and talking to them about maybe that this every so many year look back at what this is actually going to cost now is actually a better way to do it. And I'm going to skip a lot of this because we are at the end and I wanted to get time for questions, and none of that was important. So I'll put our contact info up and then I can ask what questions we have. And David can expound a little bit on agrivoltaics with our remaining 9 minutes. We'll stop sharing.
Yeah, there's a question about batteries, Paul.
We
If you
haven't
want to
seen
handle
that
that.
much battery storage yet to answer that question. We've seen a couple of sites that have been proposed that included battery storage. I do agree it comes in, but it usually comes into play on the site with the project as just something else. And if we want to get into even more crazier things, I think if you add a battery onto the site in Maryland, the county has approval over it and the Public Service Commission does not have approval. So then you get into this weird tri-county jurisdiction, or two state jurisdictions over it.
Yeah, I could maybe add a little New York perspective on that too, which is there is a lot of battery storage planned and coming online. It is somewhat riskier on a farm, probably in some ways. But I think there is growing information about sort of battery safety. The biggest concern is often about, the potential for fire. There's some pretty strong codes that have been developed around that. There is some increasing good information. We did have a couple battery fires at solar facilities in northern New York last year. That I think will become less and less frequent as they learn how to do it. There was a very thorough debriefing of that and study of what happened at those fires. And I think they found, fortunately, no long-term significant contamination out of those. So I think at least kind of the general state of feelings about the risks associated with batteries right now are actually they're more about the emergency response capacities of the municipality than they are long-term risks to the landowner specifically. But it is definitely an issue of concern. I would say it's, a low risk, but significant thing for people to be considered, make sure that there's good planning in place in case there is a problem. And yes, and also obviously the rates vary some. I don't have a lot of empirical experience for solar facilities that include battery storage on them, like how much the lease rates might or might not vary with that. So I can't really say about that. I don't know if you have any information about that, Paul, from Maryland.
None. I have none really on that. I haven't seen any of those leases. I've just heard people talk about I mean, I've mainly heard regulators talk about them. And then our next question is it prudent to have salvage value and removal costs provided by a third-party appraiser every 5 years with a linked mechanism to increase the surety bond upon completion of the new estimate? how do you cover possible environmental contamination in the surety bond? I would say it is prudent to have a third-party appraiser involved in this. At least in Maryland's system, it's probably gonna be harder to have a third-party appraiser involved in it because they're relying a lot on what the companies tell them. If it's not in that sort of similar situation as Maryland, where it's just the landowner and the developer agree to it, I would say having a third-party appraiser in there is probably gonna provide a better record, or just a better valuation than having the company do it themselves. That's been one of my problems with Maryland's system, is we rely heavily on what the company tells them within that. And not so much, I'm glad this is being recorded, but at least being put behind a paywall so no one in the state can hear me say that out loud. And then the possible environmental contamination, since this is so new, we don't know. We think the risk is low, but we've often thought that about other things with environmental contamination and been wrong much later down the road. There is some ability to, and David can add his thoughts in on this, to probably get much more folks with histories of doing just kind of like what that environmental contamination could look like from similar setups to come in and do this. I know when I worked with a firm and did oil and gas stuff, looking at some of this same type of contamination, we would use environmental scientists who had like a history of doing this to be able to put some values on what that possible contamination would look like down the road and what those cleanup costs were going to look like.
Yeah, I'll just say, I think depending on what you're thinking about environmental contamination is, solar is pretty low risk, certainly compared to oil and gas. The thing I would be tracking the most is there's not a single solar technology. It's actually, there's the newer panels. The risk, most of the risk is environmental contamination that are related to solar come not from installation on the site. The bigger risks are during the decommissioning phase and recycling or disposal phases on the one end, and at the manufacturing and sort of mineral extraction upstream in the supply chain. Those are where the really big environmental impacts that have to do with contamination are. There's obviously a lot of concerns depending on the specific site about how the runoff from the panels may or may not be quantity even more than quality. Does the hydrology change? Does drainage change? There's a lot of concern about soil compaction, sort of the construction part of the facility installation and decommissioning that could lead to different kinds of environmental issues. So I'm not saying that there's never a potential for any problems with sort of what I think of when I think of environmental contamination, but it's much lower in the actual operational phase of a solar facility on the site than it is in other parts of the process. And there are actually some of the research, particularly around agrivoltaics, coming out of sort of the work on agrivoltaics, it's suggesting there, in terms of things like soil quality, which is different than contamination, but that often solar panels can kind of give the land a breather for a while if it's been heavily used in other ways. And so there can even be actual improvements over time, not guaranteed, but in a lot of cases there can be improvements in time over in soil quality, depending especially on what kind of use it was in before it went into solar.
And I'll add to that, we've had a number, at least I've talked to a number of landowners who have agreed to put solar on and have requested that whatever wires are put in for the panels be buried deep enough that they can just stay when the project's done, because they don't want the panels pulled up, because they're thinking about it from a soil health perspective, that they'll have good soil health with just grass growing and other biological matter being added over the life that may help improve the farmland over that period of time.
And Paul, you might also comment as maybe as we're ending up here about, so there are things that the landowner needs to be concerned about in the lease. That might be one of them. However, there are also almost all of these facilities that are actually generating significant amounts of electricity also go through permitting processes, either at the local or the state level. And it's pretty typical that the permitting authority
Yeah,
will impose similar kinds of public, if you will, restrictions on the permit that either complement or sometimes even supersede the restrictions that are there in the lease. So
yeah, that's a good
in
point.
a
Yeah,
sense, are two ways at getting at these goals. So things like decommissioning bonds, public, the public sector may require that as well. You could have that in your lease too, but some version of that, but the public may require it as well. So there is some need to coordinate, between the permitting authorities, likely restrictions on what's there and what you can get in your lease.
no, that's a good point. And what I talk to landowners a lot about, at least here, is like, yes, the state process is going to dictate, how much money is there. Your job is to make sure that you're going out, taking photos, documenting what that site looked like before panels went up, before they did any work. And your job is to make sure that the lease is written in a way to where when that is decommissioned, it is restored to that site condition based on the amount of money available in the public bond, I mean, more or less public bond when it's taken down. And then I am seeing no more questions, so I am going to turn it over to our host, because I don't know how we're supposed to end this.
Thank you both so much for presenting for us today and taking extra time to answer questions. We really appreciate you being with us. This recording will be saved on our website under the member former webinars or past webinars. So you can review it there if you need to, or share with someone who missed it today. Thank you again, and I hope everyone has a great rest of their day.
Thank you, guys.
Thank you.
Bye, everyone.